Hi everybody, I'm Latanya Rudd-Gant, and I want to record this video, and it's actually way overdue. However, I just kind of thought that today would be a good time to do it, and it's unfortunate, but I've had some recent really bad experiences with attorneys, and because of that, I was thinking about how you have like elderly people and you have people just in the community that may have experiences with lawyers. And because, anytime that, you're filing any kind of lawsuit or complaint, against anybody, it's already exhausting and it's tiresome. And it's hard to deal with that, especially if it's, involving like a car accident where there are injuries or, so you have to deal with going to the doctor's appointments, you got to deal with the therapy, you have to deal with the mental anguish, the day to day, just trying to get motivated enough to even get out of bed. So I've had some experiences, but, I've always been taught that it's important to always document. And if you have like a family member and they're dealing with a lawyer and something's going on and, it just seems like they're delaying and delaying and delaying and, there are just no good outcomes, you need to make sure that you document for them or teach them or encourage them to take notes of everything, because just because I've had some really bad experiences, I thank God that I have kept lots of documentation. So I said all that to say this. So I had a case, and it actually started over 20 years ago. And I was involved in an incident where my superior officer or supervisor assaulted me. And anyways, it's been tough trying to just go on about your normal life as if nothing, you can't act like it didn't happen, but you can try to still, from day to day, put it behind you as much as you can. But, when you're a person and you've been wronged and you've been wronged, and in your heart, it's like every part of you will tell you this is not right and it has to be fixed. So for years, I just want to tell you, I want to start by saying this, for years with this particular case, it was a federal civil rights lawsuit, okay? And during the lawsuit, my attorneys, they were really good at working with me, I thought, but I don't know if it happens to every lawyer, but I think at some point, lawyers, began to treat us as if we're just a number or just a game in a courtroom. They're just, trying to win, like a game of checkers or, we're people and we're the ones that's injured. And it's hard to have to try and fight for what you know is right, okay? And then deal with your own personal injuries as well. So it's been a long time, but guess what? I have not given up, and I'm not going to give up, and I will see justice in it. So I want to give all glory and credit to God, because during that time when these horrific incidents happened to me, mentally, so y'all, let me tell you, it has taken God to keep me. We're talking about my whole life and career, everything, that I had worked for so hard. And, this was like my dream. And to have these incidents to occur, and it seems like there was no justice because it wasn't, okay? You just can't give up. Don't ever give up. But, back to what I was about to say. I give God all the glory and all the credit, because one thing that in my heart that I know it was him leading me to do is to request a copy of my entire case. Thank you, Lord. Okay? When I did that, I didn't really know at the time, that I was going to need it. And it has taken me, 19 years to open those boxes up, because it's like 9 big copy paper boxes. And I have an extra copy in a place that nobody knows about, because that's what you have to do. When you're living in Memphis, Tennessee, you better do everything that you know to do for future reasons. Okay? Let me just say that. And so, anyways, I just want to go back to what I was saying. So because within this last year, I just felt the strength to be able to revisit that case again. And because I was revisiting the case, I ran across a lot of very, very important information. Okay? And I don't understand how any human being can wrong somebody for all these years, and they knew what they were doing, and then be at peace in their heart, or to be able to sleep at night, or to even walk, or to live in fear that what if that incident or those incidents had happened to you or your loved one, your wife or your mom or your sisters. It's like lawyers get to this place where they don't really care. And they can be ruthless when it comes to money and greed, but guess what? They just ran across the right one, because I'm not afraid. And it has taken me 19 years, y'all, to look back into those cases, into those boxes, and to revisit that, just because of the mental distress. It's like, when you look at this, you're revisiting that whole scene all over again. So what I'm going to do, I'm going to read most of, I think I disconnected. I'm going to read most of the case. But I want to first start off with this. I was looking up not long ago, what is professional misconduct? It wasn't a really good definition, but it'll work, okay? It says the expression professional misconduct in the simple sense means improper conduct. In the law profession, misconduct means an act done willfully with a wrong intention by the people engaged in the profession. It means any activity or behavior of an advocate in violation of professional ethics for his selfish ends. Okay? So, these are some of the common problems. Okay? I had to look this up. Lack of communication. Okay? Because you're going to find out sometimes during your case or your complaint, the lawyers are not going to want to talk to you. They're not going to, although they're working for you and they're going to get paid, they're going to start like not wanting to tell you certain things about your case, okay? Or if you ask certain questions, because it's your case and you want to know as best as they can give you, how can you benefit? How can you be compensated for the injuries? That's what the law states. That's our right. Okay, so here's some of the common problems. Lack of communication, dishonesty. That's a big one, okay? Inaccurate billing or inadequate legal work. Okay, so it goes on in that definition to kind of break down each one. All right, so listen. So what really kind of sent me on this direction was because of the recent car accident that I was involved in. And when I saw how, when it comes to you having a lawyer, honey, everything changes when it comes to money. I'm telling you. And they can be really, really devious and mean and selfish and all of that because I've experienced it, okay? So anyways, don't let them discourage you. You keep asking questions. And if they don't want to answer your questions, that's a red flag. You need to find you another lawyer. All right? So listen. Back in October the 6th of 2003, this was actually the very beginning of where my life completely took a whole different turn, okay? Because of incidents that happened from December 2000. And then after December 2000 incident, there was another incident that happened where my coworker was on duty and he came to my home, okay? So, but I'm going to take my time and I'm going to read this because it's mine, okay? I'm going to read this. And I'm not going to try to avoid names like I did before, forget all that. Because when everything, finalizes, nobody cares about your name or they don't care about how you feel. They don't care about anything. All they care about is getting money. And they will do anything that they can if you let them to take money from you, okay? So, listen. I want to start off with this. This is a verdict form that a jury, it was a federal civil rights case, okay, which was a Title VII, okay. It was under the Act of, I think it's 1964. And, after this federal civil rights trial, which was a very high profile trial, the people that were, I guess, in power, what they did was they submitted a gag order for all the media, the news, the newspapers, and nobody could really give any kind of information concerning my case, okay? Because they knew that if the city knew about it or the county knew about it, y'all know how we do, okay? So they issued the gag order. So a lot of information nobody even knew about, okay? A lot of things in the trial nobody knew about. They only allowed certain things to be, put out there by the media. But let me tell you what the outcome was, okay? This was the United States District Court for the Western District of Tennessee Western Division, okay? Latanya Rudd, plaintiff, that's me. Shelby County versus Shelby County defendants, okay? Filed in open court October the 6th of 2003 at 6:10 p.m. This case number is going to be 3020-MA/V. Verdict form. Hostile work environment. Number A. Has plaintiff Latanya Rudd proved by a preponderance of the evidence of each of the following essential elements of her case of gender discrimination based on a hostile work environment under Title VII of the Civil Rights Act of 1964 and the Tennessee Human Rights Act against defendant Shelby County. Number 1, that plaintiff was subjected to unwelcome sexual harassment. And number 2, that the harassment was based on plaintiff's gender. And number 3, that the sexual harassment unreasonably interfered with plaintiff's work performance or created a hostile or offensive work environment that was severe and pervasive. And number 4, that supervisory employees or defendant Shelby County knew or should have known of the sexual harassment. And number 5, that the defendant Shelby County failed to take prompt action and appropriate corrective action. The jury came back and said yes, all right? If yes, go to question 1B. If no, go to question 2. Question B, is plaintiff entitled to back pay? They answered yes. If yes, go to question 1C. Amount of back pay. at the time was $9,112. Number D, is plaintiff entitled to the present value of lost wages and benefits? The federal jury came back and said yes. If yes, go to question 1E. E, amount of lost wages and benefits, $308,208, of which I received none, okay? All right. Number F, is plaintiff entitled to compensatory damages for her hostile environment claim? The federal jury came back and said yes. If yes, go to 1G. Amount of compensatory damages, $635,000. Number 2, assault and battery. Has plaintiff LaTanya Rudd established by a preponderance of the evidence that she was assaulted and or battered by Sergeant Lance Burton, and that of each of the following essential elements of her assault claim, okay, against defendant Shelby County is established? The answer is no, okay? That's only one thing that they did not agree to, all right? If yes, go on to question 2B. If no, go to question 3, okay? All right, question 3. Any individual award of compensation damages or compensatory damages with respect to a particular claim should reflect that damage caused by the act or acts of, acts on which liability is based under that claim. Plaintiff cannot recover more than once for the same damage, okay? Given these instructions, if plaintiff has established more than one theory of liability under which you can award compensatory damages, which is the total amount of compensatory damage caused by all of the acts on which you base liability, this figure will be your verdict with respect to compensatory damages. Amount of compensatory damages, $635,000. Okay. Now, let me go on to the other part, okay? So before going to... Oh, wow. Keep starting over. Okay, so before going to court on it, you need to know that, you know, even trying to get a lawyer in Memphis, Tennessee was very hard, okay? So my doctor, because everybody that I would try to go to, they would always say there's a conflict of interest, you know, because of the people that were involved, okay? So, finally, I thought I had found a lawyer, and at the time, back then, you know, he was, you know, just eager and ready to take the case. And then all of a sudden, one day he basically said to me, he can't take my case, and that it was a conflict of interest. They cannot give you any explanation. They just say conflict of interest, okay? That means either somebody they know, somebody they owe a favor to, or something, whatever. You know, whatever it is that's keeping them from taking your case, it's a personal issue, okay? So I had to go and get what's called a charge. You have to get a right to suit letter. So in the right to suit letter, when I got it, my determination was this, okay? After that, they tried to you know, mitigate it, or they tried to get both parties, myself and them, you know, to agree, you know, that, you know, whatever it is that you feel like they're at fault with, you need to come to an agreement. They could not do it, okay? So this was on September the 25th of 2001, okay? Dear Ms. Rudd, the Civil Rights Division has completely reviewed the file referred to us by the Equal Employment Opportunity Commission, that's the EEOC, in its investigation of your charge of discrimination. And it has been determined that we will not file suit in this particular matter against the respondent. This should not be taken to mean that the Department of Justice has made a judgment as to whether or not your charge is meritorious. You are hereby notified that conciliation of this matter was unsuccessful by the EEOC. You are further notified that you have the right to institute a civil action under Title VII of the Civil Rights Act of 1964 as amended, okay? And Title I of the Americans with Disabilities Act of 1990. That's another claim, okay, that was filed in conjunction with this particular case. It says, against the above named respondent. If you choose to commence a civil action, such suit must be filed in the appropriate court within 90 days of your receipt of this notice. Therefore, you should consult an attorney of your own choosing at your earliest convenience. If you're unable to locate an attorney, you may wish to contact the EEOC or apply to the appropriate court, since that court may appoint an attorney in appropriate circumstances under Section 706, okay, of Title VII. We are returning the files in this matter to the EEOC Memphis District Office. If you or your attorney have any questions concerning this matter or wish to inspect the investigative file, please feel free to address your inquiry to Doris B. Woods, Acting Director of the EEOC. Okay, so this says here, determination. It says determination, and this was issued on the same day. It says, issuing the following determination of the merits of this charge. Respondent is an employer within the meaning of the Title VII of the Civil Rights Act of 1964, as amended, and timelines, deferral, and in all requirements for coverage have been met. Charging party alleges that she was discriminated against because of her sex, that's as a female, when she was subjected to a sexual hostile work environment while working in the capacity as a deputy sheriff. Respondent contends that the allegations made against the alleged harasser were not chargeable. This is what the county said to them, okay? Were not chargeable under the department's sexual harassment policy. Respondent also contends that appropriate disciplinary action was taken against the alleged harasser for violating other departmental policies such as unbecoming conduct, truthfulness, and use of force. Evidence shows that the alleged harasser was in a managerial supervisory position and should have known not to put himself in the position of being charged with sexual harassment. Therefore, charging party, that's me, charging party's testimony is considered credible. Based on this analysis, reasonable cause exists in that charging party was subjected to a sexual hostile work environment because of her sex. Okay, now that is going to be the very beginning of everything. And let me see what time. We're at about 23 minutes. Okay. And so I'm going to read a little bit more, and then I'm going to make another video. Okay. And because I really need, I need people to know that this still goes on, and that if you don't fight them and if you don't stand for what's yours, they're not going to just give it to you. Okay. So you have myself, okay, who was the one that was filing the complaint, all right? And you had these people right here that were involved, okay? And then there's three more. There's one I didn't even know about. I never even met him. And he was an attorney that they say they allowed to carry my case before the Sixth Circuit Appellate Court, okay? And the argument when it went before the Sixth Circuit Appellate Court was the amount of money that, the judge in their in what they said was that she didn't feel like anything wrong was done, okay? And they told me that I lost my case, and they told me that I lost everything, and that they said that the judge in the Sixth Circuit Appellate Court, who was supposed to only give an opinion, okay, about the money amount, they said, oh, she reversed that whole case, and you lost everything, all right? That was a lie. So I kept digging, and I kept on digging, because you don't just let people do whatever they want to do, and it's your right. I don't care who they are, all right? You stand your ground, and you take lots of notes on everything, every phone call, every letter you get, every piece of mail you get, okay? So listen, I want to read this, and then after I read this, I'm going to stop the video, and I'm going to make another video, and I'm going to keep making videos until I complete my whole entire case, pulling all the necessary evidence, okay, that will prove that my lawyers on purpose back then, okay, intentionally resigned from my case when they knew I did not have another lawyer. I didn't even have time to find another lawyer. And with them taking on my case on a 1/3 contingency base, and then I got paperwork stating that all of them got paid. All of them got paid at the expense of my injury. No, I'm not going to sell for that, okay? And the whole 19 years, I have been so mentally affected by it, emotionally, y'all, that I didn't even have the mental strength to even look into those boxes and to read. Okay, I just couldn't do it, all right? So listen, I want you to listen to this. I'm Lieutenant K. Rudd, a former deputy sheriff for Shelby County Sheriff's Department. Here's a brief synopsis of my case. December 22nd, 2000 has changed my life forever. I was sexually harassed and assaulted by my male white supervisor, Sergeant Lance Burton, which led to him removing parts of my uniform, my clothing, rubbing his penis on my hips and my butt, during a physical struggle, and later handcuffed me to a file cabinet. Other supervisors witnessed him later draped a belly chain around me. I still can't remember that. While we were both on duty, during this whole incident, several co-workers stood by watching and refused to come to my aid. About 2 weeks later, okay, a male black co-worker, Deputy Sheriff Clarence Turks, a childhood sibling friend, came to my home, okay, while on duty, leading me to believe that he was concerned and checking on me. This visit also led to him attempting to sexually assault me, where I had to fight him off and force him to leave my home. I reported these incidents, and Lance Burton was allowed to retire happily with a full sergeant pay after admitting to everything he did. Clarence Turks, a 2-day suspension, even with his semen found on my clothing. I was later threatened by Lieutenant Alvin Moore in front of a Sergeant Carol Owens to keep quiet, or there would be great ramifications to follow. All information is included in miscellaneous exhibits. This is some of what caused the case to be won after a federal jury trial. They could not deny any of the facts. For the following reasons, I believe that my previous lawyer's behavior has been very unethical. Les Jones with Birch, Porter, and Johnson law firm has been my lead attorney from January 1, 2001 to October 2006. And in October 2003, a federal jury awarded me $952,000 in a sexual harassment lawsuit of which I received zero. In fact, my life has been left in the worst condition than ever before any report of these two incidents. I have included several exhibits that I'll refer to throughout this complaint as evidence of my complaint. After the judgment, the award amount only was appealed up to the Sixth Circuit Court. The response from the Sixth Circuit Court of Appeals is listed in full, exhibit attached. Place full attention on the last paragraph of the order sent from the Sixth Circuit Court of Appeal. We find as a matter of law that the county's actions demonstrate a good faith effort to safeguard Rudd, and that no reasonable jury could have concluded that Shelby County failed to take prompt and corrective action. Because Rudd has not proven the fifth element of the Blankenship test, we reversed the district court's order denying judgment. Denying judgment. I deny. I refuse to judge. Okay? Denying judgment as a matter of law and remand. That means go back to where you came from. Okay? And y'all need to work this out. Remand the case for judgment in favor of Shelby County. This was her opinion. That's her right there. The case was won in Tennessee, Western District. The case wasn't appealed. The award amount was the only issue. The word reverse means that the Sixth Circuit sent the judgment option back in Tennessee District, refusing to judge in the matter, okay, denying judgment as a matter of law, and remand, meaning send it back, the case to be settled by Shelby County in West Tennessee District Court. On March the 13th of 2008, at approximately 12:16 p.m., I called the U.S. Court of Appeals for the Sixth Circuit. I spoke with the case manager for the U.S. Court of Appeals. After a brief conversation, she, okay, and I have her name, informed me that the review court did not overturn the decisions of the federal jury trial, but reversed the order, okay, denying, meaning refusing judgment. She explained that the case hasn't been overturned, but sent back into Tennessee District and remanded for Tennessee to do something. Case manager directed me to contact the West Tennessee District Court and ask them what are they going to do. She further stated that the review board gave its opinion only, but they did not rejudge my whole case. After contacting the local West Tennessee District Court clerk, she advised me that the case was reversed out of Ohio's district and sent back to Tennessee's district for Tennessee to make a decision on the money amount. Now, I got to pause right there, okay? From the time that I got my award, that was when I was given the award amount, or I actually won the award amount, a few months ago, I found paperwork where everybody got paid. My lawyers got paid. The judge got paid. Everybody else they hired got paid. Okay? Now, and that was not right. Okay? That was what you call an injustice. All right? And I demand that it needs to be fixed. Okay? So, now, I said, this is what raised major concerns about my attorney's actions in handling my case at the near end. Les Jones filed a petition for, it's pronounced Soteria something, okay? Okay. To the Supreme Court. Although he got a response back, even the denial on October the 2nd, 2006, he never told me until he was giving me his letter of resignation on October the 12th of 2006. On October the 10th, I called Les Jones' office and I spoke to attorney David Goodman. I gave David all my updated personal information, and he had it already, okay? In that phone call, I asked Dave if he had heard anything from the Supreme Court. David Goodman told me no. See Exhibit 3, which will prove what happened. It includes Les Jones' letter of resignation. It includes discrepancies in dates, lies, email conversations, in the secretary's attempt to cover the attorney's unethical behavior. And I'm not blaming her. You know, she needed her job. And if it was me or her job, she's going to choose her job. Or just like anybody else that, that will just make that choice. Okay. I said, I wrote email conversations in the secretary's attempt to cover the attorney's unethical behavior, incorrect information, and misinterpretations of a ruling which has caused gross damages in my life. I have also included copies of some paperwork handed to me by Birch Porter and Johnson's receptionist about June of 2004. The tabs are still on it in red, and BPJ, that's Birch Porter Johnson's copy, the original copy of these papers have been tape covered. Okay, they have paper tape covering certain sections of a large amount of money. But when I went downtown to see the originals, in the originals, they were all blank. It seemed to me as though within the years, my attorney was more concerned about the money than my ongoing sufferings and my loss. In conclusion, for these reasons, I feel my attorneys have been very unethical. They were just flat out foul, okay? My attorney resigned from my case without prior warning, and my case wasn't over. I still had 2 conjunction cases pending in state court. I was a student temporarily living in Tulsa, Oklahoma. It was impossible for me to get home and find an attorney, okay, or hire another attorney to file for a petition for rehearing. I had to, as best as I could. Okay. Let's see here. My attorney told me that I was the biggest loser. Okay. I begged and I pleaded with him not to quit. It was very devastating for me. Yeah. This was very unethical, and it was just foul, and it was just wrong on so many levels, okay? on his part. He just dropped me, y'all. That's how they'll do you. They will drop you. So you better do your homework. And you better make copies. You better send copies of your stuff to a relative or somebody, because don't trust them, okay? He says, and I went on to say, it was very devastating for me. This was very unethical on his part. He just dropped me in my whole case of 6.5 years without notice. He told me that there was nothing left to do or nothing left to collect. He, Les Jones, also stated that Judge K. Batchelder was an African American. That was a lie. And he couldn't believe that she would make such a ruling. Well, she was Caucasian, not black. These were all lies. I may not know how much he was paid, but it is very obvious that he was. And then I told you a few months later, I found the paperwork, okay? These are some of the ongoing damages as a result of my entire case. And I'm going to stop right there, and I'll pick up on the next video. Thank you for watching. Please share. Please share my video. Like it, share it. Especially you guys, that are young, like in your 20s. Share it. Please share it. Share. All my cousins, my great cousins, my nieces, my church members, share this video. I am not going to stop. Justice will be served, okay? Somebody is going to make this right. Thank you.